With the enactment of these three parliamentary legislations, India is set for a significant overhaul of its criminal justice system. The Bharatiya Nyaya Samhita, the Bharatiya Nagrik Suraksha Samhita, and the Bharatiya Sakshya Adhiniyam will, as we all know, replace the Indian Penal Code of 1860, the Code of Criminal Procedure of 1973, of course, which was preceded by the CRPC of 1898, and the Indian Evidence Act of 1872. These laws, in a sense, are a watershed moment for our society, because no law affects the day-to-day conduct of our society like the criminal law. Criminal law directs the moral arc of a nation and has the ability of depriving people of their cherished liberties as well. The underlying justification of substantive provisions is the principle, which is best summarized in the saying, "Your right to swing your arm ends just where the other man's nose begins," which governs crimes from the state of setting the criminal process in motion to the conviction for the commission of the offense, ensures that no person is charged and subsequently convicted for offenses without the due process of law. The one thing which was the striking aspect of our triad of criminal laws was their age, 1860, 1872, and even 1973. And I think the enactment of these laws by Parliament is a clear indicator that India is changing, India is on the move, and that India needs new legal instruments to deal with current challenges and the challenges which we envisage for the future of our society. The traditional harm principle found resonance with the understanding that crime is immoral. The father of criminology, Rafael Garofalo, defined crime as an immoral and harmful act that is regarded as criminal by public opinion because it is an injury to so much of the moral sense as is possessed by a community, a measure which is indispensable to the adaptation of the individual to society. The ideals underpinning the combination of harm and immorality are premised on the perception that deprivation of liberty leads to repentance and to moral salvation. There were two problems with this harm-linked approach to criminal jurisprudence. The first was that it is not a victim-oriented approach. The impact of the harm on the victim is not considered. Victims of crime often feel like their agency over their own decisions is lost by the commission of a crime. Our laws have therefore to aim to give victims a sense of agency and control in the criminal process, as well as a sense of justice. The second problem with the juristic foundations of our earlier laws was in regard to the harm and immorality of approach, and that was that it advances a perpetrator perspective to crime, which views crime as an individual failing. It does not address systemic causes which push people to commit crimes. For example, a law addressing gender